Today programme on BBC Radio 4. We're going to take back control. That was probably the slogan that had the most resonance in the referendum campaign. It summed up the message from the Leave camp. Britain would no longer be run by Brussels. We'd make our own trade deals, decide who could come to live here, and be ruled by our own courts and not the European Court of Justice. We'd escape their jurisdiction. Well, this week we shall learn how that might work. Position papers will be published by the government. Battle lines will be drawn. Let's talk to two people who know a great deal about that particular court. One is Martin Howe, QC. He's a specialist in European Union law. And the other, Sir David Edwards, who was himself a judge, an ECJ judge on that European court. So it might come to you first, if I may, Sir David. What do we mean when we talk about escaping jurisdiction, the jurisdiction of the ECJ? What does that actually mean? What is its jurisdiction?
Well, the Court of Justice has two jurisdictions. One is to deal with direct actions, which are actions against EU institutions, against by one member state against another, by a member state against an institution. I don't think that's at issue here. The other jurisdiction is to answer questions on the interpretation and application of EU law put to it by courts of the member states. So there is no sense in which the ECJ has jurisdiction in the United Kingdom in the same way as the Supreme Court of the United Kingdom has jurisdiction. All that the ECJ can do is to answer questions put to it by a court of the United Kingdom or by a court of one of the other member states.
Right, so therefore, if we leave not just the European Union, but specifically the important institutions, the customs union and so on, they have no jurisdiction over us.
They don't have any jurisdiction over us in that sense anyway. All it means is that British courts cannot put questions to the Court of Justice about the application of EU law, but of course it can continue to answer questions put to it by French, Italian, Slovenian courts as to the application of EU law, where that affects British traders, British individuals, British professionals in operating within the EU. So that continues.
Right. And as far as people, EU citizens living in this country after Brexit, they would still be able, at least this is what we assume, obviously this will be sorted out in the negotiations, but they would still be able to appeal to the ECJ.
No, the individuals don't have any right of appeal to the ECJ.
By appeal, I mean come under the general jurisdiction of the ECJ. In other words, whatever the ECJ rules upon in Europe would be applicable to them here.
Well, no, because a British court after Brexit cannot put a question to the ECJ, and therefore there is no way in which matter arising within the UK could give rise to the ECJ ruling upon what happened within the UK, unless that was agreed as possible.
So, Martin Howe, once we become independent of the European Union, you would agree, would you, that we would not be locked into the EU on anything?
Yes, I agree with Sir David on that subject. And furthermore, this isn't just some sort of weird ideological thing by Brexiteers. We've done a close study of every single European Union free trade and association agreement with a non-member state, and not a single one of them provides for the non-member state to be subject to the direct jurisdiction of the ECJ, not even Andorra. That has a conventional bilateral international dispute settlement process where each party appoints an arbitrator and there's a neutral third-party chairman, as indeed, with slightly more elaborate provisions, the Canada-EU agreement. So that is definitely the international practice and the international precedent.
Right. So when Sir Paul Jenkins, he was the government's most senior legal official for many years, wasn't he, until 2014, he wrote in the Observer yesterday, didn't he, that Britain would have to replicate EU rules and submit to the ECJ in all but name if, for instance, it wants to remove the need for hard borders. Is that right?
No, I don't think that's right. There are two instances in the European Union's external treaties where you have indirect shadowing of the judgments of the ECJ by non-member states. One case is in the case of Turkey, which is a member of the customs union, and they have to follow the ECJ on interpretation of the common rules of the customs union. The other case is the EEA states, Norway and so on, under the European Economic Area Agreement, where their EFTA court follows the ECJ. But in both cases, those states have chosen to become members of a dynamic rule-based system and have agreed, in effect, to follow the interpretation of the rules by the ECJ. We would be leaving both of those constructs, trading with the European Union as a non-member state, and there's no reason why we should give any precedence to judgments of the ECJ any different from the precedence we give to judgments of the US Supreme Court, supposing we were to enter into a trade agreement with the USA.
Do you agree with that, Sir David?
Well, I think that's simplistic, because it's all very well talking about Andorra. The number of cases that are likely to arise as between the United Kingdom and any country of the 27, and in particular between Northern Ireland and the Republic of Ireland, is greater than any number of cases that are likely to arise between Andorra and the EU. So let's be realistic. The EFTA court deals with cases arising in Norway, Iceland or Liechtenstein, involving the EEA treaty, which includes the basic freedoms in the EU treaties. That court has a staff of, at the moment, 20 full-time and 1 part-time, and has to contract out all translation services. It has 3 full-time judges and a full-time staff. Now, you have to imagine that there would be some institution in the United Kingdom, or somewhere in the middle of the Channel, which would be capable of dealing with the number of issues that are likely to arise between the UK and the EU 27.
Right.
No,
sorry, I was just going to go back again to Sir Paul Jenkins, because he said that the Brexit Treaty will need to provide a parallel policing system, and that may be a new court, but in reality any new court would have to follow what the ECJ says about the EU's own rules. Is that right?
Well, if it depends on the rules you choose to make. If you decide we are going to float free into the middle of the Atlantic and away from the Republic of Ireland and away from the other European countries, that's perfectly true. But if we're wanting to trade, to create a level playing field as between us and the EU 27, then we will have to replicate a great many of the rules that are in EU law.
And you
can't
would
get away from it.
Sorry,
That's what Norway, Iceland and Liechtenstein have to do.
Right, and you'd have to accept that, wouldn't you, Martin Howe?
No, there's an important point here. When you have an international treaty, it's accepted international practice and court practice that the courts of the states who are party to that treaty will look at each other's judgments in order to try and be consistent in the way they interpret the treaty. And there's nothing wrong with that, and that's in fact highly desirable. But that's very different from having either a system where the courts of one party are binding on the courts of the other, or a system where they're obliged to follow the jurisprudence. And it's that that's undesirable.
Do you think, either of you, that this could prove a serious stumbling block, resolving these issues could prove a serious stumbling block, or is it a matter of, a lot of argument and eventually we'll get there because, in the end it's not that complicated? Or is it that complicated, Martin Howe?
Well, I mean, I don't think it is, except the European Commission has made it complicated because in its current position paper on the status of EU citizens in the UK, it's actually asking for direct jurisdiction by the ECJ over our courts. And it seems to me they're in outer space on that. It's completely incompatible with international practice. You'd have to go back to the 19th century and the unequal treaties with China, under which extraterritorial British, French, and so on courts adjudicated the rights of their citizens inside China to find anything similar to what they're asking.